Hi everyone, I hope you're having a good day or night so far. My name is Sienna Pingelli, and I will be presenting my case review on R v. Nuljov, which is a 2022 Supreme Court of Canada decision. I do just want to briefly state that this case does talk about some sensitive topics. This case is in regards to Section 7 of the Canadian Charter of Rights and Freedoms, which states that everyone has the right to life, liberty, and security of the person, and the right to not be deprived thereof, except in accordance with the principles of fundamental justice. To start off with the facts of the case, back in 2011, 19-year-old Eugene Nuljov committed two sexual assaults in the same night during a house party in Alberta. Then, in 2015, he pled guilty to those two counts of sexual assault. The sentencing judge found that he was unlikely to reoffend and imposed a 6-month imprisonment following with 3 years of probation. He was mandatorily required to register as a sex offender under the Criminal Code. However, since he had two convictions, a lifetime registration was also mandatory. Nuljov challenged the sex offender registration under Section 7 of the Charter, stating that they violated his right to liberty, were overbroad, and disproportionate. The courts had the task of addressing two issues. The first one was whether the mandatory registration of sex offenders and the lifetime registration for multiple offenses violated Section 7 of the Charter. Secondly, if those provisions do violate Section 7 of the Charter, can it be justified under Section 1? As for the outcome of the appeal and the decision on the legal issues, this was a majority won by the court. The court found that both provisions, in accordance to the sex offender registrations, violated Section 7 of the Charter and could not be justified under Section 1. The court enforced a 12-month suspension on the mandatory registration to allow for Parliament to alter the provision, where the lifetime registration for multiple offenses was invalidated and struck from the Criminal Code. Due to this, Nuljov was exempted from the registration during the suspension period, and a re-evaluation would take place once Parliament amended the section. The court's explanation for the decision was based upon that the Criminal Code sections infringed an individual's right to liberty, were overbroad, and disproportionate. They stated that it infringed the liberty of a person because the registry obligations, such as reporting and random checks, severely imposed on personal autonomy and freedom of movement. The sections were declared overbroad because they required individuals who posed no increased risk of reoffending to register, such as Nuljov was found to be a low-risk offender, yet he was going to have to be subjected to random checks and having to report to multiple authorities. They also acknowledged that having multiple convictions in one incident does not mean that the individual has a higher risk of recidivism. Due to all these reasons, they found the provisions disproportionate to Nuljov's case and in violation of his Section 7 rights. This case relates to the course material and the key themes in this course, as the court would have needed to apply the Section 7 two-step test we discussed in lecture. For the first part of the test, which is to demonstrate that any or all of the right to life, liberty, or security had been deprived by law. The second part of the test is to demonstrate that the deprivation is not in line with the principles of fundamental justice. As previously mentioned, the court did find that the law was infringing on Nuljov's right to liberty, satisfying the first part of the test. As for the principles of fundamental justice, the law can be found to not be in accordance with the principle of overbreadth. This is because the lifetime registration for multiple offenses automatically applied to Nuljov, even though his offenses were in the same event. No individual risk assessment was allowed for these cases, and the social purpose of the law in this case was not reasonably necessary. As for arbitrariness, the automatic nature of the registry was inconsistent with the law's purpose and the objective of it, which is for public safety, making the provision not in accordance with this principle. How can subjecting someone to continuous social stigma, even though they have been found to be at low risk for recidivism, protecting public safety? Lastly, vagueness was not a big issue in this case, as the law was clear and understandable, but did not allow for judicial discretion. The second aspect of course material that applies are the trilogy cases. The PHS case was about access to safe injection sites, but also allowing room for more judicial discretion, like we see in the Niljof case, where the provisions of the criminal code did not allow for judicial discretion. However, amendments were made so that judicial interpretation can be applied more broadly. In the PHS case, the courts had the discretion to go one of two ways, applying the facts of the case, setting precedent on the discretion of judges. The Bedford case was in relation to the criminalization of sex work. Like the Niljof case, the laws put individuals in unnecessary risks and stigma. In the Bedford case, laws around sex work force sex workers to put themselves in dangerous situations to avoid criminalization. In the Niljof case, the risk was social stigma of being on the registry and the restrictions of their movement, always being watched. In the Carter case, the courts were tasked with the issue in relation to medical assistance in dying. This case set precedent where even if the government claims the laws for public safety, such as sex offender registry, it can be unconstitutional if the mandate violates a freedom, like what happened in the Niljof case. Moving on to a recent event in Canada that is related to my case, it's the case of Haroff. Unfortunately, there was a publication ban on this case, so I cannot find any court documents. However, a news source reported slightly on the case, and it gives a good idea of the aspects of it. In November of 2020, an 18-year-old BC man recorded and shared a video of a 13-year-old girl being sexually assaulted. When given the option to in 2024, Haroff pled guilty to making and distribution of child pornography. He was sentenced to a jail term with 18 months of probation following. However, he was not required to register as a sex offender due to the changes of the provision in the criminal code based on Bill S-12, which resulted from the Niljof case. The Niljof case allowed for judicial discretion to be broadened and proportionality to be applied in certain cases. Haroff's crime would have mandated him to register as a sex offender due to his crime being a designated offense as per the criminal code. However, due to the changes based on Niljof and Bill S-12, by assessing Haroff and his situation, the judge found him unlikely to reoffend. And as per the new provisions, the judge used their discretion to not mandate him to be registered as a sex offender. Based on my presentation, I have created a couple discussion questions to think about and respond to. Firstly, should the courts have the power to exempt individuals from mandatory laws if those laws are shown to be overbroad or arbitrary, even if their aim is to protect public safety, like sex offender registries? My second question is, the Supreme Court of Canada emphasized that laws must not be arbitrary or overbroad, even if they serve an important social purpose. How should lawmakers balance public protection goals with individual charters' rights? Thank you so much for listening to my presentation, and I hope you have an amazing rest of your day.